Hello, and welcome to the next installment of our state law privacy videos, where McDermott's global privacy and cybersecurity team examines different aspects of the new state privacy laws and provides you with the knowledge and tools needed for compliance. Now, if this is the first state law video you're seeing, be sure to click the link below for our other videos. Today, we're going to look at the Data Protection Assessment, or DPA requirement, that the new laws in Virginia and Colorado introduce. Now, careful listeners heard me right. Just Virginia and Colorado today. California's CPRA does not have a similar DPA requirement, at least not yet. It will have a requirement once we see the regulations, which we're told might come in Q3 or Q4 of this year. Another thing that we will do a little differently in this video is that we will talk about Virginia and Colorado laws together because the DPA requirements are substantively identical. Now let's start with what is a data protection assessment. While we anticipate regulation to add more meat to the bones, both laws require assessments to identify and weigh the benefits from the processing to the business that the consumer and the other stakeholders against the potential risk to the privacy of the consumer. Now, DPA should also consider how risks might be mitigated, such as through de-identification, in the context of the processing the relationship with the consumer. So when are DPAs required? When personal information will be processed for targeted advertising, profiling, if that profiling has a reasonably foreseeable risk of unfair, deceptive, or otherwise negative impact on a consumer's. An example would be a denial of a financial product. Selling data, processing sensitive data, and be sure to check our video on what constitutes sensitive data, and the generic anything else that presents a heightened risk of harm to the consumer. Now, thank goodness, however, a single DPA can address multiple processing operations that include similar activities. And so more practically, modeling off of GDPR's data protection impact assessments and accounting for the differences between the GDPR and Virginia and Colorado's new laws, DPAs likely should include an analysis of, one, the nature of the data processing at issue, that is, the targeted advertising, for an example. 2, a description of the personal information that will be processed. 3, the safeguards in place to ensure the security and fidelity of the data that will be processed. 4, the purpose for the processing. 5, any other factors that may be relevant to evaluating the risk inherent in the processing, such as whether the personal information will be shared with third parties. And 6, ultimately, a conclusion as to whether the origin, nature, and particularity and severity of the risk posed by the processing weighed against the benefit of the processing. Finally, in both Virginia and Colorado, the respective attorney general can request a business provide their DPA so that the attorney general can evaluate the business's compliance with applicable state law. The good news here is that the information in the DPAs and the DPAs themselves are not subject to open records laws like FOIA at the federal level, and the disclosure does not waive any privilege or work product protection that would otherwise exist as to the DPA. That's a lot to cover in a short bit, but that's it for our overview of the new DPA requirements in Virginia and Colorado. In our next video, we'll examine the service provider contracting requirements imposed by these new laws.